Gentleman from Kentucky is recognized.
I thank the chairman. Mr. Trustee, is it true, or do you believe, I'm going to ask you to speculate on something, that some of these cases are going to get overturned even if they do get a prosecution in their current venue?
Yeah, I do think that when prosecutors are being inventive for historically important prosecutions, that they can collapse of their own weight. And maybe that is for misconduct in Georgia, maybe that's for a novel felonization of misdemeanors in New York. But I do think that it puts a lot of pressure on the appellate courts, but they may well get to that point where trial judges go along with the game, but the appellate court does not.
So isn't it a characteristic of lawfare sometimes that you don't really care how the case is going to end up, that the process is the punishment?
Sure. I mean, look, for any client, it is strain and stressful to go through an accusation and a trial. It's got to be particularly maddening when you're running for president to be going through that, to be tied up in New York courtrooms for most of the day. So, yeah, it is. There's a win without a win for the proponents of lawfare sometimes.
Mr. Hamilton, I want to talk about the special counsel office in general. The Appointments Clause of the Constitution says the president shall nominate and with the advice and consent of Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. Are U.S. attorneys nominated by the president and confirmed by the Senate according to the Appointments Clause?
In fact, they are.
U.S. attorneys are held to the Appointments Clause because they are delegated some part of the sovereign power of the United States, such as the ability to make indictments and charge individuals with crimes. Was Jack Smith nominated by President Biden or confirmed by the Senate?
He was not.
He was merely given the powers of the special counsel by Attorney General Garland, wasn't he?
That's correct.
I think it's kind of a fallacy that Congress can create this special office and that it will be free of any political bias. Do you believe that Special Counsel Jack Smith is acting independently of the White House?
Absolutely not.
And what leads you to believe that he's not?
So it's not only the novel application of some of these statutes to former President Trump, twisting statutes that this Congress wrote, twisting the meaning of plain language, of sections like 1512C, interpreting the Presidential Records Act in a way that precludes Donald Trump from deciding which records are his. There's all kinds of different things that he's doing. But I would say that the manner in which they've been acting, as my colleagues on this panel have testified to, the manner in which they have conducted themselves in their investigation, every step along the way, whether it's cataloging evidence or whether it's statements to the court and everything in between, Jack Smith is acting like a partisan hack. And he has a record of that doing so in the past.
And, according to reporting, Jay Bratt, a top aide to Special Counsel Jack Smith, met with White House officials multiple times, including just weeks before Special Counsel Smith indicted President Trump. I mean, it's hard to say that he's independent if these meetings are in fact going on, isn't it?
That's correct.
I think maybe we need a hearing later on to talk about this office itself and how it's been weaponized. I'm going to yield my remaining time to the chairman.
I thank the gentleman for yielding. Mr. Trustee, you've talked about earlier Jack Smith's obsession with getting this trial done before, in a speedy fashion, I think before the election, I mean, it seems to me, that in and of itself, all of them are concerned. These trials may not happen before the. Why does that matter? We want justice done right. That should be the focus, not some artificial timeline.
I think the speedy trial demand betrayed the political underpinning of the entire process. There's no reason for a federal prosecutor with a non-incarcerated defendant to say anything. And if I could just for a quick sec, the model here, there was a real obvious model that would have given us all more faith in this process. That is full transparency on behalf of the Department of Justice. Coming into court and saying, we're turning over everything in discovery, we're ready for trial, but Judge, you tell us we'll show up when we need to show up. We're here for small j justice, not capital J justice, as we used to say at DOJ. That's the problem. That model of transparency and openness, not fighting special master supervision, not appealing everything, not trashing Judge Cannon in Florida, that's what we could have had some respect for and some belief that the process is playing out fairly.
You only bring charges after he announces for president, then of course you want the trials before the election. That seems so obvious, I think, to anyone with common sense. That's what they're trying to do. Now, the good news is it's all falling apart. It's all falling apart, which when you have these kind of cases, maybe that's what we should have probably expected in the end. I think the gentleman for Young Chair now.